Good afternoon, everyone. This is the Office of Consumer Credit Commissioners stakeholder meeting to discuss the pre-comment draft of rules for commercial sales-based financing. My name is Matt Nance, and I'm the OCCC's General Counsel. I'm joined by other members of the OCCC staff, including Commissioner Leslie Pettyjohn, Director of Licensing, Finance, and Human Resources, Moran Diamond, Director of Consumer Protection, Christine Graham, Deputy Director of Consumer Protection, Carl Hubenthal, and finally, Assistant General Counsel Vivek Vedanarayanan and Paralegal Nico Fisher, who are acting as our meeting organizers. I have a couple of quick housekeeping items. We are holding this meeting through an online webinar, and I want to thank everyone for joining us. If you joined us for our webinar in November, welcome back. And if you're joining us for the first time, welcome as well. Getting input from stakeholders is a really important part of our rulemaking process, and these meetings help us make sure we produce the best rules possible. Our webinar platform is GoToWebinar. Some of you might be listening on your phones, some may be watching on a computer, and some might be doing both. For those watching on a computer, there's a questions window where you can submit comments to staff. And if you have technical questions about using the webinar, you can type them in that window, and Nico will try to answer those questions. So we'll be discussing a pre-comment draft of rules that we posted on the OCCC's webpage for recent and upcoming rules. On that webpage, you can see the draft, the pre-comment draft by clicking on the link for commercial sales-based financing rules. I'd like to do a high-level summary of the rules, and then I'll lay out the tentative timeline, and then you'll have a chance to provide comments. So I'd like to start with a quick refresher on the product and the law being implemented by these rules to make sure we're on the same page. So the product and regulated area that we're talking about is called commercial sales-based financing. And this is a new area of regulation for our agency and a new registration requirement based on a law passed in 2025 by the Texas legislature. So what is commercial sales-based financing? It's defined in the new law, House Bill 700, passed by the Texas legislature last year. This is a type of financing where a recipient business repays financing as a percentage of sales or revenue. Either payment amounts can increase or decrease based on sales or revenue, or there's a fixed payment mechanism adjusting payments to a percentage of sales or revenue. So the statutory requirements from the new law, those include a registration requirement. So the statute requires providers and brokers of commercial sales-based financing to register with the OCCC. And like I said, this is a new area of regulation for our agency. Oh, excuse me, I need to go back into my PowerPoint. There we go. Okay. There are exemptions under the statute for banks, credit unions, certain technology providers, transactions secured by real property, transactions extended to motor vehicle dealers and rental companies, and certain other transactions. Disclosures are required for transactions less than $1 million, including the total amount of financing, disbursement amount, finance charge, repayment amounts, and the period for payments to equal the repayment amount. There are certain other prohibitions, including a prohibition on confessions of judgment, as well as certain automatic debits, unless the provider holds a perfected security interest in an account with first priority. And finally, for rulemaking and enforcement, the bill authorizes the OCCC to administer, implement, and enforce the new chapter, Chapter 393. It authorizes the OCCC's oversight body, the Texas Finance Commission, to adopt rules to administer the chapter, including rules on practices considered unlawful, unfair, deceptive, or abusive, which includes practices taking unreasonable advantage of a recipient's lack of understanding. So the law generally went into effect on September 1st, 2025. The new law is located in Chapter 398 of the Texas Finance Code. So from now on, I'll try to refer to it as Chapter 398 or the statute. So the statute provides that no later than September 1st, 2026, the Finance Commission will adopt implementing rules and requires providers and brokers to register with the OCCC no later than December 31st, 2026. So that's the high-level summary of the statute at Chapter 398, and now I'll move to the pre-comment draft of the rules that would implement the statute. So the first set of rules in our pre-comment draft is rules 86.301 through 86.307. These rules deal with the registration requirement. So registration will be through the Nationwide Multi-State Licensing System, or NMLS, which is an online licensing system used by the OCCC and other state agencies throughout the country for licensing and registering financial institutions. Applicants would be required to provide information about the company as well as key individuals. This would include information described in Chapter 398 about civil, regulatory, and criminal violations of law that resulted in orders or judgments. Registrations would be effective for a one-year period from January 1st to December 31st, and registrations and renewals would be subject to a fee for administering the registration program. Our pre-comment draft has a new rule on disclosures. It's section 86.310. It explains that the disclosure form given to the recipient under Chapter 398 must be accurate, and the contract must include a notice on how to contact the OCCC as well. There is a record-keeping rule at section 86.311. It explains that providers and brokers must maintain a transaction file with disclosures and contracts. That file would need to be maintained until the later of 4 years from the date of the transaction or 2 years from the final entry. There would also be provisions on agreements with third parties, such as an agreement between a provider and broker, as well as data security information and information on any data breaches. So the next key area of rulemaking would be a rule implementing the prohibition on unfair, deceptive, or abusive acts or practices, which include practices causing substantial injury, misleading practices, and practices taking advantage of a lack of understanding. So this new rule at 86.312 would include prohibitions on false, misleading, or inaccurate advertisements, solicitations, disclosures, or contract language, provider or broker's failure to perform contracted for services, charging fees or other amounts that were not specifically disclosed and contracted for, waivers of statutory rights, foreclosing on collateral without complying with applicable requirements, improperly characterizing a transaction as commercial when advance funds will be used for individual, family, or household purposes, and a device or subterfuge to evade regulatory requirements. Next, at 86.313, we would have a rule implementing the prohibition on certain automatic debits in section 398.056 of the Finance Code. As a reminder, section 398.056 states, a provider or commercial sales-based financing broker may not establish a mechanism for automatically debiting a recipient's deposit account unless the provider or broker holds a validly perfected security interest in the recipient's account under Chapter 9 Business and Commerce Code with a first priority against the claims of all other persons. So the OCCC has prepared two different draft versions of this section and invites comments from stakeholders on these versions to implement section 398.056. Both versions would provide that debits are automatic if they are authorized in advance to occur more than one time or on a recurring basis. Regarding the security interest, version A would focus on a security interest on the deposit account itself, while version B would focus on having a security interest in all accounts receivable. Finally, there would be additional rules on administration and enforcement, which would include authority to conduct an investigation on receiving a complaint or other reasonable cause to believe that a provider or broker is violating the law, a requirement for providers and brokers to make records available for inspection and respond to requests for information, a requirement to maintain transaction records, a requirement to maintain updated contact information, authority for the OCCC to issue enforcement orders, including injunctions, restitution orders, administrative penalty orders, and orders to suspend or revoke a registration, and a rule on suspension or revocation based on criminal history, again, implementing the requirement for a registration applicant to provide information on civil or criminal violations of law. So that's the general summary of the amendments in the pre-comment draft. Here's a tentative timeline for these rules. You can see that we're requesting informal pre-comments by this Friday, January 30th. We would plan to propose the rules at the Finance Commission's February 2026 meeting. There would be an official comment period during the month of March 2026, and we would plan to present the rules for adoption no later than the Finance Commission's August 2026 meeting, with that requirement for providers and brokers to be registered no later than December 31st of 2026. This is, of course, a tentative timeline, and all of this is subject to the approval of our oversight body, the Finance Commission. Oh, okay, our presentation exited out of the slide. Let me go back. There we go. Okay, so with that, I have summarized our pre-comment draft and can open things up to comment. There are two ways to provide your feedback through this webinar. First, you can type your comment out and send it through the webinar's question feature, or if you're on a computer with a mic, there should be a function allowing you to raise your hand. Also, if you have a longer written question, you can feel free to type a quick message into the question field and go to webinar explaining that you have a longer message. Okay, I'm taking a look for hand raises. I'm seeing we have a hand raise from Alan Pollock. So could we unmute Alan Pollock to get that verbal comment?
Can you hear me?
Mr. Pollock, you may.
Yes, we can hear you.
Okay, very good. Good afternoon. I wanted to ask, you mentioned that there's going to be an NMLS registration requirement and also an OCCC requirement. Are those two separate requirements, or is that one and the same?
Okay, great question. So the question was, is the NMLS registration separate from the OCCC? It's the same registration. So the requirement is to register with the OCCC. NMLS will be the system that providers and brokers use to obtain their registration with the OCCC.
Okay, also, is there a requirement for, let's say a business is based into New York and they were funding Texas merchants, is there a requirement to register with the Texas Secretary of State or register as a foreign entity, or is this the only registration requirement that's needed?
So that might be required. You might want to consult counsel who can advise you on that. But generally, to do business in Texas, businesses do need to register with the Texas Secretary of State. I mean, you may want to get with counsel to determine whether a particular company is the type of organization that requires that registration with our Secretary of State. But generally, yes, registration with the Secretary of State is required, and we would expect to see some documentation of that registration when a business gets a registration through us. So generally speaking, at a high level, I can't necessarily provide legal advice outside of our areas of the finance code, but generally we would expect for a business first to register with the Secretary of State to do business, and then to be ready to provide that documentation as part of the materials to get a registration with our office.
Through the NMLS, you mean?
Yes.
Okay,
Correct.
I'm sorry, and if you'll allow me with just one more question. One of the slides mentioned that a contract for services must show how to contact the OCCC. Is that to say that the contract that creates between, let's say, a funder and a merchant in this case, would need to have a special section in the contract to say that in the event of whatever goes on, just here's how to contact the OCCC? Is that what you mean in the contract for services, that there needs to be an ability for the merchant to know about the OCCC and information about how to contact them?
Yes, and the rule text does have text for that provision. It's in the pre-comment draft of rules close to the top of page 5. This is in section 86.310, subsection C. So it says the contract for services under Texas Finance Code Chapter 398 must contain the following statement. And then there's some language about how for questions or complaints about this contract, contact the provider. So it would have both the provider's information to encourage contacting the provider, but then would also say the Office of Consumer Credit Commissioner is a state agency, and if a complaint or question cannot be resolved by contacting the provider, the recipient can contact the OCCC to file a complaint, and then it would have our contact information.
Very good, thank you.
Sure. Okay, we have a few hand raises, so I will get to those in order. So the next one we have is from Patrick Cuff. Can we unmute Mr. Cuff?
Mr. Cuff, you may unmute.
Hey, Matt. Thanks for holding the webinar. I thought that the pre-draft comments or pre-draft regs make a lot of sense. I think that there's been good progress from the November iteration, so appreciate everything that you guys have been doing so far. More of a comment than anything, just pointing out that we are in strong support of version A of 86.313 on the certain automatic debits. We think that it takes close statutory alignment to what the legislature wrote. And it's very clear in what is dictating an automatic debit, and specifically where the security interest for a deposit account aligns to the statute and to the regulations. So just pointing out that we are, one company, but in strong support of version A, and think it aligns very well to 398.56. So thanks again for the work, and look forward to continuing to iterate this with you guys.
And thank you for that comment, Mr. Cuff. Could you remind us what company you're speaking on behalf of?
Fiserv.
Okay, thank you. Okay, the next hand raise we have is from Catherine Fisher. Can we unmute Ms. Fisher?
Ms. Fisher, you may unmute.
Thank you, Mr. Nance. Can you hear me?
Yes, I can.
Excellent. Thank you so much. My name is Kate Fisher. I am a partner with the law firm Hudson Cook. Hudson Cook is a law firm that focuses on regulatory compliance matters for providers of financial services, and we've been closely watching this process. And I want to thank you, Mr. Nance and Commissioner Pettyjohn, for the opportunity to comment, and also just comment that the proposed regulations were clearly very thoughtfully drafted and took a lot of time and care. I wanted to acknowledge that and thank you. I have one comment and two questions. my comment goes to option A and B. In our view, option B, which provides for a perfected security interest in all of the accounts receivable of the recipient, is the version that most closely aligns with Texas law. I'm not going to get into a long discussion of or recitation of statutory interpretation rules under Texas law, but be happy to elaborate if you would like. And then I have two questions, both of which are related to the list of acts and practices in section 86.3.12 that would be considered unfair, deceptive, or abusive. My first question is about the sections of that list actions that are required under the regulations. And my question is the intent that would be 2 violations of the law or 1? So specifically, the list includes failure to provide accurate disclosures, which is a separate obligation under the regulations. And it also, under the draft, would be an unfair or deceptive or abusive act in practice. So is that intended to be 2 violations under the rules, or would that be 1?
Okay, good question. I think it could be 2 because there are certain required disclosures, and if a business fails to make a required disclosure, that could be that wouldn't necessarily be a false, misleading, or inaccurate statement. It would be a failure to make an accurate disclosure. I think I see where you're coming from, that certain types of statements, I guess, could violate both. In which case, we would try to reach a resolution to bring the business into compliance. This and the enforcement rule, I don't think they're about kind of gotchas or creating a multiplicity of violations. Our intent is always to try to reach compliance. If we can reach that through, the complaint instruction process, we try to do that. If it's necessary to go to enforcement, our preference is to resolve things first through an injunction rather than getting to assessing penalties for multiple violations. So I think I see where you're coming from. A single act could potentially violate separate provisions, but I could also see situations where there are distinct violations of those provisions, especially where a business is failing to make disclosures. And in either case, what we would be trying to do would be to try to get to compliance and not, rack up the sake of violations just for the sake of doing that.
That's really helpful. Thank you. And just one other question. The section that addresses improperly characterizing a transaction as a business or commercial transaction when the advanced funds will be used for individual, family, or household purposes. In my view, it would be very difficult for a sales-based financing provider to police what is actually done with the funds. And my question is there a way to solve for this that a company can implement without being obligated to police how the recipient actually uses the funds? And I'm asking you because I don't have an answer, Mr. Nance, as I've been thinking about it, something to propose, but I wanted to bring that up as a potential section of the rules that perhaps could use some revision.
That's a good question. I think looking at some of the concept there ties into other statutes that our agency currently enforces, especially Chapter 342 of the Texas Finance Code, which governs consumer loans, which are loans extended primarily for personal, family, or household use. So there's already this requirement that if the loan is for personal, family, or household use, you would trigger a different statute and should probably be operating under as a regulated lender under Chapter 342 rather than as a commercial sales-based financing business. So that's the concept we are kind of borrowing from. I think knowing the customer is important and prudent for businesses, but we invite pre-comment on that because that was a concern we had about this particular area was, are these arrangements being made when they're really effectively consumer loans just labeled as a commercial or business product? So that's the concern we're trying to address. If there's an approach to address that stakeholders can think of, we would definitely be interested in that. But that's a little bit of background on the problem we're trying to address with that and the legal source and reason for businesses to be prudent about it.
And if I may, this is Leslie Pettyjohn. I just wanted to emphasize the point that Matt made. We have had some enforcement cases or issues in the past that we've concerned about where we've seen activity that is truly for business, for personal, family, or household use, and that is being labeled as business or commercial use to attempt to evade certain elements of other parts of law. And we don't want this activity to be used in that same way where someone is making an advance of funds and they're really attempting to do so for personal, family, or household use and not for legitimate business or commercial. It's not an attempt to make a desire to make providers be the police, so to speak, but it is an attempt to get to those device or subterfuges that we see in other areas and to be sure that this area doesn't become a vector for that as well.
Thank you. No more questions for me. Thank you.
All right, thank you. Okay, we have a written question from Scott Stewart and also a hand raise. I'll go ahead and read the question and then let Mr. Stewart, if he wants to speak, supplement the written question. So Mr. Stewart's written question is, my question involves version B of 86.313, contemplation of the prohibition of certain automatic debits. While we appreciate that the OCCC was given responsibility under 398.005 to administer, implement, and enforce the chapter, the state legislature in enacting this law was fairly defined and prescribed in articulating actions the OCCC may take through rulemaking. Equally, the enacting law was clear in articulating under 398.056 the type of accounts that require a perfected security interest. Particularly, the statute states that automatic debiting may not occur from a recipient's deposit account. The statute does not direct the state to review or further define the meaning of this section. Can the OCCC please expand on its intent behind version B and provide an articulation on where the OCCC believes the statute provides it with the subjectivity to deviate from deposit account when considering rules related to auto debiting? I guess let's go to the hand raise. Mr. Stewart, do we still have a hand raise for Mr. Stewart? And If so, could we unmute him and see if he has anything to add to that question?
Mr. Stewart, you may.
Thanks so much. I really appreciate it. And we really appreciate you giving us this opportunity to comment. I don't want to add anything to it. It was a pretty detailed question. And so that's why I put it into the chat for you. I'm looking forward to hearing your response.
Sure. So as we've already heard in this webinar, we've had at least one stakeholder believes version A is preferable or better implements the statute. We have at least one stakeholder saying version B. When we had our call in November, I think there were some differences of opinion about what the meaning of that section is, especially you know, in looking at that section. In the first part, it talks about deposit account. In the second part, it talks about account. And how do we understand that? For provisions, for areas where Chapter 398 defines a term, I think it's correct that we go with the statute's definition, and it's not really necessary for us to redefine those terms in the rule. But we need to have rules that implement this statute, and I think part of that could include specifying or interpreting provisions that are otherwise unclear. So kind of generally, as an agency, you know, the legislature sets out general provisions in the statute, and to properly function, we may need to be able to interpret or define undefined terms that are in the statute. And as to this issue specifically, again, I think we're getting at what, when the statute uses the phrase deposit account at one point and then uses the phrase account, we're trying to get to what does that refer to, that the account that the security interest needs to be in. We've gotten already, you know, feedback on both sides of that, so we're definitely interested in what stakeholders think about those two versions and interpreting that provision. Okay, Mr. Stewart, did you have a follow-up on that question?
Not at this time. I appreciate that you're balancing both potential options.
Okay, thank you. Okay, we have some written questions that I'm going to try to get to. So we have a couple from Jean Rosen, or actually 3 from Jean Rosen, so I'll take those in order. Okay, question 1 from Jean Rosen, written question. During the previous webinar, the OCCC expressed some concerns about credit card split transactions where the credit card processor turns over the specified percentage of receipts to the funder being covered by the restriction on ACH debits. Based on the draft of the rules, is that still the case? So we didn't address credit card splits in this particular draft as credit card splits. So if that is a debit of an ACH account, it might be subject to the prohibition on certain automatic debits. But otherwise, you know, we don't mention the term credit card split in this rule. If stakeholders have feedback on that, you know, please feel free to send that as a pre-comment, or if you think some sort of future rulemaking on that is appropriate, you know, please feel free to include a pre-comment on that. Question 2 from Mr. Rosen. Based on the draft of the rules, it would seem that a funder could ACH debit a merchant if each debit is initiated manually. For example, a funder could contact the merchant on a periodic basis to confirm that an ACH debit will be initiated manually. Is that correct? Okay, so again, this is something the rules are and the statute are silent on, is these kind of manual debits. So it's not that the rules state that that's authorized, the rules are silent on that. If stakeholders have feedback on that, we welcome that feedback. Okay. The third question, I have seen services from Mr. Rosen. Third question, I have seen services advertised where a merchant can sign up for a service to automate payments to the funder. Only the merchant would have control over the process. Would this be covered by the restriction on ACH debits? And again, I think under these rules, what we'd be looking at is there more than one time or recurring debit to a deposit account? I think that's what we'd be looking at for the applicability of that prohibition. Again, we welcome feedback from stakeholders on how that implements the text of Chapter 398. Okay, any other written questions or hand raises?
There are no other questions or hand raises at this time.
Yeah. Okay. Okay, I do want to make sure we've gotten to all questions and hand raises. So I'm going to wait 1 minute just to see if we have any others. If you have a, oh, we have a hand raise from Mr. Pollock again. Can we unmute Mr. Pollock?
Mr. Pollock, you may unmute.
Hey, can you hear me?
Yes.
Okay, sorry about that. I just want to get confirmation of when these new rules come into effect. So I understand that this is still a comment period. What is the date that providers of commercial financing will have a final draft to be able to read and implement and understand? And will we have like another meeting to be able to discuss those once they're finalized?
Good question. So the rules would go into effect at least 20 days after the Finance Commission finally adopts them. So our oversight body, the Finance Commission, meets every other month. So for example, if these rules, and we're not totally sure yet at which meeting the Finance Commission will finally adopt the rules. So, you know, by statute, it needs to be before September 1st. But for example, if they're adopted at the June Finance Commission meeting, stakeholders would be able to see the adoption, and there would be a 20-day period after they're adopted before the rules finally go into effect. So will there be another stakeholder meeting? Typically, we don't have an additional webinar stakeholder meeting for rules that have been formally proposed to our oversight body, the Finance Commission. Stakeholders could still listen in to the Finance Commission meeting where the rules are proposed and then finally adopted. We typically don't do another webinar, but there is another opportunity for official comments on the proposal. And like I said, there's at least a 20-day period between the Finance Commission adopting a final version and the rules going into effect. I'm going to go back a slide to the timeline real quick, just so we can remind ourselves. So yeah, there is this kind of two-part process for formally presenting the rules to the Finance Commission. First is proposal, and then is formal adoption. And in between those, there's an additional opportunity for stakeholder comment. And then a 20-day period before the rules are legally effective. Okay, we have a hand raise from Patrick Siegfried.
Mr. Siegfried, you may unmute.
Yes, thank you. I just wanted to again say thank you to the commissioner for being able to put this together and present us an opportunity to comment on the proposed rules. My name is Patrick Siegfried. I am with the firm Murray Legal. I represent providers of sales-based financing. I just wanted to voice my support of option B. I believe it's the clearest and most appropriate interpretation of the legislature's law of HB 700. Additionally, I believe it would resolve some of the practical concerns of sales-based financing providers that have already led to their restriction and inability to continue to provide financing to sales-based finance recipients in the state of Texas. And believe that if the commission moves forward with option B, it would be a great step in guaranteeing that these merchants have continuing access to credit or have access to capital where needed. Otherwise, in response to option A, I believe we're going to see a further reduction in access to capital available to Texas sales-based finance recipients. Thank you.
Thank you. Okay, we have a written question from Brianna Cook. Will these disclosure requirements apply to agreements that are already in existence or only for ones executed after the effective date? So the rules would have a prospective effect. They would apply to agreements entered after the rules go into effect. Now, the question is these disclosure requirements. So I should point out that the statute, Chapter 398, generally went into effect on September 1st, 2025. And there is a statutory disclosure requirement under section 398.051, which is part of chapter 398, which generally went into effect on September 1st, 2025. So the safest course would be for, if you're talking about disclosures required by the statute, the safest course would be to already be providing those starting September 1st, 2025. But as to the rule, the requirements under the rules, those would apply starting on the effective date of the rules. Also, I should say, if stakeholders have a particular recommendation for what the effective date of the rules should be, we are, please feel free to include that in a pre-comment, since our timeline is still tentative. So if there's a particular recommendation about what the when the rules should go into effect. They do need to be adopted by September 1st, and we need to have the registration system set up so that the providers can be registered by December 31st. But if stakeholders have a particular thought about when the rules should be effective, please feel free to put that in a pre-comment. Okay, so question from Jean Rosen. During the previous webinar, it was not clear if the OCCC would be issuing a form for the required disclosures. Is there any additional clarity at this time as to whether or not there would be an additional form for disclosures? Okay, this is a really good question. We did see what we noticed in the feedback from the last webinar is there's a really substantial variety in how different businesses disclose information and enter their agreements. We don't currently have, and it's not part of this rule, a model form for the required disclosures. The legislature in the statute didn't specifically mention adopting a model form. So we don't have one at this point. I seem to remember there was a little bit of interest from some stakeholders in that, but there was also a big variety of what the disclosures might look like. So for now, we don't have a model form, but if there's interest in adopting one in the future, please feel free to include that in the pre-comments. Any other hand raises or questions?
There are no other questions or hand raises at this time.
Okay. Okay, well, like I said, I want to make sure we get to all of those, so I will wait for 1 minute or so just to make sure. If you have a longer written question, please feel free to type something in saying you have a longer question. But otherwise, we will wait 1 more minute. Okay. Well, again, I do want to thank everyone for joining us and participating. So rule updates are available on our website, and we'll also be posting the audio of this meeting. Again, we are accepting informal written pre-comments until 5 p.m. this Friday, January 30th. Please email those to me at rule.comments@occc.texas.gov, which is our email address for rule comments. Thank you all for attending. Please be safe out there, and we'll see you next time. Thank you.